In this lesson, what we're going to do is spend a little bit more time talking about constitutional conventions. This will be the last, I believe, lesson on constitutional conventions. We may do some more in the future in some more advanced subjects, or when we do some more videos looking at constitutional theory. But for now, we're just going to talk about the general theoretical debate that surrounds the enforcement of conventions. Now, you might think that this is somewhat contradictory to what you have been told and what you've been taught, and you'd be right. There is a little bit of academic debate about the extent to which conventions are able to be enforced within the broader framework of the UK's constitution. So this is going to contribute to the interesting debate, or at least outline the interesting debate. I'm not going to try and claim any kind of novelty to any of these views. We're going to basically outline the debates surrounding the enforceability of constitutional conventions. If they are enforceable, to what extent they're enforceable, to what extent is this enforcement something of a legal enforcement, or whether or not it is political or maybe moral in nature, the nature of where this enforcement comes from. So, when it comes to constitutional conventions, you have been told by me, and you have been told by probably everybody who has taught you constitutional law, that they are by their very nature non-binding instruments. This is even something that is cited by A.V. Dicey in his writings. Constitutional conventions are by their very nature non-binding. You cannot bind an individual legally to the upholding of a constitutional convention. But when we say that they are non-binding instruments, we are implying here that they have no enforcement whatsoever. This is true in regard to their operationalization in the courts. The courts cannot enforce or impel an individual to uphold a convention, to follow a constitutional convention, at least not necessarily. But this does not necessarily mean they have no enforcement whatsoever, that there is no ability for there to be enforcement in their regards. Do they lack enforcement in their entirety just because they cannot be enforced by the courts? Well, this is really where we see the arguments for enforcement. The easiest argument to levy here is that while they are not legally binding, and A.V. Dicey is correct that a constitutional convention is not legally binding, their nature as a rule of thumb, which is generally followed, implies that they are at the very least seen to be followed for the most part. So they are not necessarily legally enforced, but they can be, because of their nature as being general rules of thumb which are followed by all, followed on that basis. And in which case, the statistics back this up as well. For the most part, people who are bound to a convention, or somebody to whom a convention applies, follows them for the most part. There are some obviously notable examples where they do not, and there are examples where there is a lack of enforcement of conventions, but for the most part, conventions generally appear to be followed more so than they are not followed. And so this leads some academics to the view that enforcement of conventions are something of a political or moral enforcement rather than a strictly legal one. There's a political obligation that somebody has to follow the conventions that have been in place for the hundreds of years of the UK government. And this may be the case. There may also be moral reasons for enforcing legal conventions. But there are even people who exist in academia who make the argument that while it is the case that there is political and moral enforcement, it doesn't just stop there. We are not suggesting that it stops there, and that there is actually strictly legal arguments for legal enforcement. And so when we talk about legal enforcement, academics, some may take the stronger view, suggesting that the mere recognition of a convention by a court is tantamount to their enforceability. So there have been examples in the past, and it is very common for courts who are adjudicating on matters of administrative law or of constitutional law, of just a general public law or human rights. They will recognize the existence of conventions. They don't just ignore that they exist. They would recognize that a convention exists and that the convention has this sort of ability. And some academics take the view that the mere recognition of a convention in this way is tantamount to their enforceability. This is the argument that was presented by T.R.S. Allen in his work Liberty and Justice, the Legal Foundation of British Constitutionalism. But this doesn't look like enforcement in the same way as a court would enforce the law. Courts, when they enforce the law and when they apply the law and when they make judgments on the law, they're not just recognizing the existence of the law. They are actually looking at the existence of the law and that they are applying the law to the facts of the particular case. Just merely recognizing the existence of a convention does not necessarily mean that it is tantamount to its enforceability. It could potentially be tantamount to their potential enforceability, meaning that whereas it is not enforceability in and of itself, the idea of the courts recognizing the existence of conventions is moving us towards a situation where conventions are becoming more and more in the legal jargon of courts and tribunals in public law cases. So in the future, it could be the case that at the moment, right now, we have just the mere recognition of conventions, but maybe in 10, 20, 30, 40, 50, 100 years' time, the courts may have more of a say and make more of an indication as to conventions, talk about conventions more in legal judgments, and then maybe start to shift towards enforcing the views of conventions in more detail. This is, of course, a heavily debated and critiqued position to hold, but it is one that exists. For the most part, however, we would say that if there is any convention enforcement that exists, if there is any enforcement that can exist for conventions, they exist as a way of some kind of political enforcement, some kind of moral enforcement, not necessarily a kind of legal enforcement.